On the night of August 3, 2024, emergency responders raced to a quiet home in Elkhart, Indiana. Inside, they found a 6-year-old boy, unresponsive, his small body bearing injuries that would tell a story his father desperately wanted to hide. His name was Justin Elmore, and while he couldn't speak for himself anymore, medical science would give him a voice. This is the story of how forensic evidence became the silent witness that exposed a father's lies and brought justice to a child who deserved protection. Elkhart, Indiana, a city of about 53,000 people, in the northeast corner of the state, just miles from the Michigan border. It's a community known for its manufacturing industry and tight-knit neighborhoods, the kind of place where people know their neighbors, where families put down roots. In one of those neighborhoods lived 29-year-old Franklin Elmore Jr., his wife Cheyenne, and Franklin's 6-year-old son from a previous relationship, Justin. Justin Elmore was in first grade, 6 years old, still learning to read, still figuring out the world, still at that age where everything is new and full of possibility. On that August night when paramedics arrived at the Elmore home, they found Justin unresponsive in the playroom. The injuries were serious, too serious for a child. Franklin and Cheyenne told first responders they had no idea what happened. In fact, they suggested something that would later prove to be impossible. They claimed Justin might have done this to himself. Let that statement sit. According to the couple, Justin had behavioral issues. They told investigators the boy would, quote, hit himself in the head. They suggested his injuries could have been self-inflicted, that perhaps Justin had hurt himself during some kind of episode. But when medical professionals examined Justin at the hospital, that story fell apart immediately. The Elkhart County Medical Examiner's findings were clear and unambiguous. Justin had sustained a traumatic brain injury, the kind of severe trauma that requires significant force. He also had internal injuries, including damage to his lungs. These were not injuries a 6-year-old child could inflict on himself. The force required, the location of the trauma, the nature of the injuries. Everything about the medical evidence contradicted Franklin and Cheyenne's explanation. This wasn't speculation. This wasn't opinion. This was objective medical science stating a simple fact. Justin's injuries came from an external source. Someone had hurt this child, badly, and despite what his father claimed, Justin hadn't done it to himself. Justin's body was telling a story his father didn't want anyone to hear, but medical examiners would make sure that story was told. Before we continue, I need to ask for your help. Stories like Justin's reach people because you share them. Every share, every subscription means another person who might recognize warning signs in their own community. If this story matters to you, please hit the like button and subscribe. And in the comments, let me know where you're watching from and what time it is. It helps me understand when to publish these investigations so they reach the most people. This channel exists to give voice to children who couldn't speak for themselves. Every case we cover is a lesson in recognizing dangerous situations. Knowledge like this could one day help you protect a child who needs it. Now, let's talk about Miranda McBride, Justin's biological mother, and the warnings she tried to give months before that August night. To understand what happened to Justin, we need to understand his family situation. Justin's biological mother, Miranda McBride, lived out of state. Like many separated families navigating custody arrangements, she relied on communication, trust, and cooperation to ensure her son's well-being from a distance. Franklin Elmore had custody of Justin, and Franklin had remarried. His wife Cheyenne was Justin's stepmother. But in the months leading up to August 3rd, Miranda McBride had become increasingly concerned about her son. She would later tell investigators and local reporters that she had tried to warn authorities that something was wrong. Those warnings, as we'll see, would be at the center of heartbreaking questions about what could have been prevented. Miranda wasn't the only one with concerns. She would later reveal that she'd been alerted to potential problems by someone inside the family, Franklin Elmore's own mother. Justin's grandmother had seen enough to reach out. But before we get to those warning signs and what was or wasn't done about them, we need to understand what investigators discovered when they dug deeper into the Elmore household. because Justin's injuries on August 3rd weren't the beginning of this story. They were the tragic end. As Justin fought for his life in the hospital, detectives from the Elkhart Police Department began piecing together what really happened inside the Elmore home. What they found would paint a very different picture from the story Franklin and Cheyenne had told. In criminal investigations, especially those involving children, physical evidence is crucial. And in this case, some of the most damning evidence came from an unlikely source: the suspect's own phones. On both Franklin and Cheyenne's cell phones, investigators found photographs. These images showed Justin with visible injuries, bruises, marks on his body, documented over a period of time. Let that sink in. Think about that for a moment. Someone had photographed this child's injuries multiple times, creating a digital timeline of harm. The photos revealed an undeniable truth. This wasn't a single incident. This wasn't one terrible moment of lost control. This was an ongoing pattern. According to prosecutors at the Elkhart County Prosecutor's Office, Justin had been subjected to what Franklin and Cheyenne called, quote, whoopings as punishment. Now, many parents use some form of physical discipline. That's not what we're talking about here. These weren't typical parental discipline. Investigators learned that Franklin and Cheyenne allegedly used their hands to strike Justin. They allegedly used a belt. And, perhaps most disturbing, they allegedly forced Justin, a 6-year-old child, to exercise for hours as a form of punishment. 6 years old, first grade age, a child who should have been learning his ABCs, playing at recess, being tucked into bed at night with a story and a kiss. Instead, according to court documents that would later be filed, he lived in an environment where punishment had escalated far beyond any reasonable limit. When emergency responders and medical personnel examined Justin on August 3rd, they noted something else in their reports, something that speaks to how long this had been happening. Justin had injuries in various stages of healing, some new, some older, some that had already begun to fade. This is what medical professionals call a pattern of abuse. Evidence that a child has been harmed repeatedly over time, evidence of a dangerous environment that had gone unnoticed, or at least unreported, for longer than anyone wanted to imagine. Remember Miranda McBride, Justin's biological mother, living out of state, trying to protect her son from a distance. In the months before Justin's death, Miranda had tried to sound the alarm. She didn't just have a feeling something was wrong, she took action. According to Miranda, she contacted Indiana's Department of Child Services, known as DCS, to report concerns about Justin's safety. She later told local news station WNDU that she was told authorities, quote, could do nothing because they didn't find any bruises, no visible bruises. So no action. Miranda lived out of state. She couldn't physically see Justin regularly to document injuries. She was operating on information she received from others, trying to navigate a system designed to protect children while also respecting family privacy. But Miranda wasn't working alone. She wasn't just imagining problems. She revealed that she had been alerted to the situation by Franklin Elmore's own mother, Justin's grandmother. Someone inside the family had seen enough to be concerned, enough to reach out, enough to say, something isn't right here. This raises critical questions, questions that extend far beyond this one case in Elkhart, Indiana. When a grandmother reaches out with concerns, when a biological parent reports potential harm, when there are warnings from within a family, what mechanisms exist to investigate? What evidence is required before authorities can intervene? What resources do child welfare agencies actually have to assess risk and protect children? Child protective services across the country are often understaffed and overwhelmed. Caseworkers carry heavy caseloads, sometimes responsible for dozens of families at once. The balance between family privacy and child safety is genuinely complex, and the consequences of both action and inaction can be severe. In this case, by the time medical professionals did see Justin's injuries, by the time there was undeniable, visible evidence that something was terribly wrong, it was too late. While Franklin and Cheyenne's story was falling apart under police investigation, the most powerful testimony was coming from an unexpected source, Justin himself. Not through words he couldn't speak anymore, but through medical evidence. This is where our title comes from: the silent witness. Forensic pathology has become one of the most crucial tools we have in protecting children who cannot speak for themselves. When a child dies under suspicious circumstances, medical examiners do far more than just determine a cause of death. They can analyze injury patterns. They can determine the force required to cause specific trauma. They can distinguish between accidental injuries and intentional harm. They can tell whether the explanations given by caregivers match the physical evidence. In Justin's case, the medical examiner's findings were absolutely clear. The injuries he sustained, the traumatic brain injury, the internal trauma, were inconsistent with self-inflicted harm. The force required to cause those injuries, the location of the trauma, the pattern and severity, all of it pointed to external causes. All of it contradicted everything Franklin Elmore had told investigators. This is what forensic experts call objective evidence. It doesn't rely on witness testimony that can be contradicted. It doesn't depend on who's telling the truth or who's lying. The body tells its own story. And in cases involving children who may be too young to articulate what's happening, too frightened to speak up, or like Justin, unable to speak at all, medical evidence becomes their voice. Justin Elmore couldn't tell investigators what happened in that playroom on August 3rd, but his body could. Medical science gave him a voice when his own had been silenced, and that voice was about to echo through an Elkhart County courtroom where Franklin Elmore would finally have to face the truth. Franklin Elmore Jr. was charged with murder in the death of his son. His wife, Cheyenne Elmore, was also charged with murder for her alleged role in Justin's death. Both initially entered not guilty pleas. Franklin's trial was scheduled to begin on November 3rd, 2024. Prosecutors had their evidence: the medical examiner's findings, the photographs on the phones, the pattern of injuries, the testimony about what life had been like for Justin in that home. They were ready to present their case to a jury, but that trial would never happen. Shortly before his trial was set to begin, Franklin Elmore made a decision. He would plead guilty to killing his son. According to reporters from WNDU who were in the courtroom for the hearing, there was no plea deal on the table, no negotiation with prosecutors where Franklin would plead guilty in exchange for a reduced sentence. This was what's called an open plea, where a defendant pleads guilty without any agreement about sentencing, essentially throwing himself on the mercy of the court. The exchange in court was brief but revealing. Franklin Elmore's own defense attorney asked him directly, "Did you knowingly kill another human being?" Franklin Elmore responded, "Yes, sir." The attorney continued, "Do you acknowledge you physically beat your son and he died?" Franklin Elmore's response, "I did not mean it." Let that sit. 4 words, "I did not mean it." 4 words attempting to soften accountability, to suggest that somehow this wasn't as bad as it seems, to imply that intent matters more than outcome. But intent does matter in criminal law. It affects the specific charges and potential penalties. And Franklin Elmore had just admitted to knowingly killing his son. Whatever he meant or didn't mean, whatever his intentions were, his actions had taken Justin's life. And now, by pleading guilty, he had acknowledged that fact in open court. Franklin Elmore's sentencing is scheduled for November 25, 2024. Because he pleaded guilty rather than being convicted at trial, the death penalty is not on the table. In most states, including Indiana, capital punishment can only be imposed after a jury trial and a separate sentencing phase. But Franklin Elmore still faces life in prison. When someone pleads open to the court like this, the judge has significant discretion in sentencing. They'll consider multiple factors: the defendant's age and criminal history, whether there have been prior incidents, prior contacts with law enforcement, or child protective services, the severity and nature of the crime itself, in this case, the death of a 6-year-old child in the defendant's care, whether the defendant shows genuine remorse, and whether their actions in court suggest they're taking full responsibility or still minimizing what happened, and whether there are any mitigating circumstances that might argue for leniency. For a case involving the death of a child at the hands of a parent, judges typically impose the harshest penalties available under law. We'll know Franklin Elmore's sentence on November 25th. As for Cheyenne Elmore, Justin's stepmother, her case will unfold separately. She has maintained her not guilty plea, and her trial is scheduled for February 2025. A jury will hear the evidence about her alleged role in Justin's death and decide whether she, too, should be held accountable. Justin's case raises questions that extend far beyond one family in Elkhart, Indiana. Questions that communities across the country are grappling with every day. When a grandmother reaches out with concerns about a child's safety, when a biological parent reports potential harm, when there are warnings from within a family, what mechanisms exist to investigate those reports? What evidence is required before authorities can intervene in a family? And what resources do child welfare agencies actually have to assess risk and protect children who may be in danger? These aren't easy questions, and they don't have simple answers. Child Protective Services agencies across the country are often understaffed and overwhelmed. Caseworkers carry enormous caseloads, sometimes responsible for dozens of families at once, trying to assess risk, monitor compliance, and make life-or-death decisions with limited time and resources. The balance between family privacy and child safety is genuinely complex. We don't want a system where any allegation automatically results in children being removed from homes. But we also need a system that can act when children are genuinely in danger. The consequences of getting it wrong in either direction can be devastating. According to Miranda McBride, she was told authorities couldn't act without visible evidence of abuse. Without bruises, they could see and document. She lived out of state. She couldn't physically examine Justin regularly. She was operating on information from others, trying to work within a system that has rules and requirements. And by the time medical professionals did see Justin's injuries, by the time there was undeniable, visible evidence, it was too late to save him. These aren't problems that will be solved overnight. But they're problems that demand our attention. From policymakers who allocate funding for child welfare services, from communities that need to understand how to recognize and report warning signs, from all of us who believe that children deserve protection. Justin Elmore was 6 years old. He should have grown up. He should have gone to second grade, then third, then middle school. He should have made friends and discovered what he loved. He should have learned to ride a bike, played sports, read books, watched movies, had birthday parties. He should have become whoever he was meant to be. He can't. But his story doesn't have to be in vain. Building toward mission statement. When medical science gave Justin a voice, when forensic evidence exposed the lies, when accountability was finally achieved, justice spoke for a child who couldn't speak for himself. That's what we mean when we say we're seeking justice for the voiceless. Every case we cover, every story we tell, every victim we remember. Justin Elmore's life mattered. His story matters. And the lessons from his case, the importance of protecting children, of listening to warnings, of letting science be a voice for those who can't speak, those lessons matter. On November 25th, 2024, a judge will decide Franklin Elmore's fate. But Justin's legacy, the reminder that every child deserves protection, that warning signs must be taken seriously, that justice must be sought for the most vulnerable among us, that legacy will endure. If you found this story important, please consider subscribing to True Crime Buff HQ. We're committed to telling these stories with dignity, depth, and a focus on justice for victims. If you or someone you know has concerns about a child's safety, the Child Help National Child Abuse Hotline is available 24 hours a day, 7 days a week at 1-800-4-A-CHILD. That's 1-800-422-4453. You can also visit childhelp.org for additional resources. Thank you for watching, and thank you for caring about these stories.